This is a Momentum Media production.
The SMSF Adviser Show. Your expert insights into the biggest themes shaping the SMSF advice industry.
Hi everyone, and welcome to the SMSF Adviser Show. I'm joined by Aaron Dunn, a Smarter SMSF CEO. Welcome, Aaron.
Thanks, Miranda. Great to be here once again. So 2022 is kicking along now, and certainly been a busy start to the year with news. Probably the big one for me is I was head down, bum up in terms of getting all my presentation done for the SMSF Association conference, and that has now been deferred from what was February through to April 2022. So I've got a little bit more downtime, I guess, at the moment, which is a big relief.
Yeah, it takes the pressure off you at least. So that's one good thing. Yeah, I guess like everything else, COVID sort of impacted that. But yes, they've sort of earmarked it for April. So hopefully that date goes ahead. Yeah,
so hopefully we're past the peak, which I think Victoria and New South Wales seem to be maybe over that hump, fingers crossed. And yeah, we get to April and we see something that might look a little bit more COVID normal as we're going forward. So in terms of what else is making news, Miranda, what's driving traffic on the SMSF Adviser site, and what else are we hearing on the technical front?
So we're starting to see a bit of submissions and commentary on the ATO's consultation to move to a single timeframe for T-bar reporting. We've seen submissions from the SMSF Association, the NTAA, and one of the Tax Institute as well. So, yeah, while most of them have been quite supportive, they've also sort of highlighted that professionals are under a lot of pressure at the moment. So it's probably better to have a later start date for this rather than one that's this year.
Yeah, so this, I think we spoke about it in our last podcast, or maybe the one before even. So the ATO obviously had their consultation in terms of moving the needle to a permanent regular reporting framework. So we do currently at the moment have our annual and quarterly reporting timeframes for transfer balance cap events within SMSFs, using our TSB threshold of $1 million or more to determine which framework that we fall within. And interestingly, as you said, we've seen most of the professional bodies here come back and talk about this notion of a 1 July 2023 start date rather than 1 July 2022, and all off the back of, with systems, processes, COVID challenges, workload. And yeah, I think it naturally makes sense. I know the ATO sort of also spoke about, well, do we need to go beyond quarterly? And I think all that has sort of been pushed way, way, way back into the back burner to say, look, let's get our industry moving towards a quarterly time frame, but not before 2023. The Tax Institute, interestingly, just also sort of raised some stuff around some safe harbours for the point of view of determining valuations if we don't have a readily identifiable value, say the audit and stuff hadn't been done, if we had a 1 July pension. So there are some safe harbour provisions there that will allow for the reporting of amounts to be done in accordance with best estimates. So, there's a lot of what I call common sense in here, and I'm sure the ATO taking on board that common sense, I think we're more than likely to see that 1 July 2023 come into fruition. And I suspect that they would probably announce something like that, within the next 6 months or so, to ensure that there is a sufficient level of time for people to start to sort of get ready for that. And because there will be software changes, there'll be reporting changes, there'll be a whole range of stuff. So it will take us time to readjust to what would be that regular reporting timeframe if it is to become quarterly from 1 July 2023.
Yeah, the other thing we saw come out this week was the impact of the new insolvency legislation on SMSFs and how that might impact a fund that has a corporate trustee.
Yeah, so at the beginning of 2021, there were changes made by the government to the insolvency framework to better support businesses and creditors and employees and so forth. So in essence, the impact for self-managed super funds is that this insolvency process includes a new category of disqualified persons, and then naturally that disqualified persons requirement fits into the SMSF framework when we think about the definitions in section 17A. So in essence, we now have arrangements whereby they are captured in respect to this legislation. So if a fund has a corporate trustee and a restructuring practitioner is appointed, the company will no longer be able to act as a corporate trustee as it's disqualified. And then we go through that process to ensure that within 6 months, we continue to meet the definition of a self-managed super fund.
The other one, another bigger story that we saw was that Dixon Advisory has filed for voluntary administration. Obviously seen that firm be hit with a few different types of legal proceedings, particularly in the last 12 months. So it's been in a bit of hot water for a while. And I guess that's kind of just led them to make the decision to go through this voluntary administration.
Yeah, so there's this is an organisation that is one of the larger in the SMSF space for a long period of time. Some 4,000 odd clients that as SMSFs are there. I think we'd seen some clarity recently about were trustees exposed because a lot of the administration may have already been paid for the coming year and had that work been done. It appears as though Evans and Partners will, in essence, have will run the administration. So they, in essence, have an Evans and Partners SMSF administration service, which is, in essence, replacing what the Dixon Advisory SMSF admin was doing. So, because you've got to remember that it's not just Dixon's here. We do have a cohort of Evans and Partners clients as well. So there will be some form of migration of those clients. I believe I read somewhere that there's a commitment to obviously the fees and stuff that are being paid where they do remain, but equally there has been questions that have been asked by trustees about saying, what do we do next and so forth, and do they actually go off and seek the administration of their fund elsewhere? And I guess the long and the short of it is there will be advice coming through the administrators in respect to how that works. I'm sure there has been through the Evans and Partners business and those employees that were working at that organisation as well.
We also saw ASIC put out a bit of a warning on cryptocurrency. Obviously, that kind of asset class has been getting a bit more interest from SMSFs at the moment. So they've warned SMSFs, particularly those that haven't even set up a fund yet, but on some of the risks with investing in those kind of assets and, just to be wary.
Yeah, so it's an interesting one because clearly SMSFs are in the firing line here because it's really the only superannuation structure that could hold these types of investments. I think I was reading somewhere recently the other day that even with the dip recently with Bitcoin and the like, that more sophisticated investors in SMSFs, there's been a lot of the providers had seen an uptick in SMSFs coming into these. But really what ASIC is saying here is just be aware of your risk and return, be aware of all of the elements that really sit within a fund's investment strategy. And similarly to what we saw through the last few years with the investment strategy and the use of LRBAs in property and so forth, how are we demonstrating how a fund is appropriately investing in different classes of assets to meet the overall objectives for retirement for the members of the fund? So it has a very similar tone to it. ASIC quite clearly is looking at providers like they did with real estate, the single model where you'd have the promoter and they would get a clip of the fee on the property and they would also maybe do the funding and then they do the administration. They are targeting providers who are unregulated in this market as well. So, we're seeing a different product line, but a very consistent approach by ASIC to this information to make sure that trustees are aware of not only their responsibilities, but the risks that are imposed by doing these particular assets, and therefore you're not covered in the event of these assets potentially going bad like you are within an APRA-regulated environment.
We're going to move to our second segment now, and we're going to be joined by SMSF Alliance Practice Principal and SMSF Specialist Mentor, David Busoli. Obviously, COVID has been placing some additional pressure on relationships and marriages, and we've seen a bit of an increase in marital separations as a result of that. So we're now joined by David, who's going to give us a bit of a rundown of the practical elements involved with family law super splits. Welcome, David.
Thank you, Miranda.
Can you give us a bit of a quick overview of the main options with superannuation splitting for SMSFs and the basic sort of steps that need to be followed, particularly in terms of administration and the documentation that needs to be provided?
Well, quite often what happens is that we only become aware of the details when we receive the splitting orders. And that causes a little bit of a problem because there's quite a lot of things that we need to deal with. And I suppose we shall talk about them in a moment. But the big thing that we always need to be cognizant of is that divorce is not a bacon and eggs type thing. It's a highly emotional and emotive situation. And you're not just dealing with SIS and tax rules, which of course we have to comply with. You're dealing with people and emotions. And we're going to assume for much of this chat, I know, that things are amicable, but it's not always the case. And when it's not the case, and we have one right now, which is absolutely nuclear, it throws the rule book out the window entirely. Maybe we'll come back to that at the end.
Yeah, and David, the real interesting thing there is, and you alluded to it, is that typically the relationship of trustees is not equal. I know we talk about equal representation in SMSS, but we typically see SMSS with a more dominant director or trustee, and that is naturally going to throw up some challenges in its own right.
We do, and particularly since the warring parties, and hopefully they're not warring a lot, are in the same fund, usually, and are both trustees. This is not like an APRA fund where it's a relatively a simple situation in comparison. SMSF throw up some challenges.
What are some of those challenges? I mean, when you think about the way that consent orders are constructed and so forth, do you want to touch on, what you expect to see, and therefore, from an administrative perspective, how you need to go about dealing with those different types of consent orders that are issued?
Well, you've hit the nail on the head there, Aaron, that we need the consent orders or the splitting orders or the agreement. There's only two ways that we can get instruction, either by way of a binding agreement, which has been put together by the spouses or ex-spouses in conjunction with their own legal advice. But generally speaking, we get an order, a splitting order, consent order, or what have you. And that can take one of two forms. And there's lots of variations here. It can either be a base amount where there's a fixed amount that's got to be paid from one party to the other, or there's a percentage split. And if there are particular types of pensions, which we don't often see in SMSS, but we could have complying pensions, then there's also a split on benefit payments going forward. I'm not really going to talk about that in any detail because that's rare, but it is something that can occur. The problem that we've got, though, is when we receive these orders, unless there's been a great deal of thought into the actual formulation of the detail of them, we can find ourselves in a very difficult situation in trying to comply and trying to fit a square peg into a round hole. With the, by the it is, but I just mentioned one thing on that. You've got the fixed amount or the percentage. There is a particular consideration as to whether or not a member will have one or the other. If it's a fixed amount, and we happen to be, as we did with one case that I was involved in the middle of a major market correction, and it was a fixed amount, the guy staying in the fund ended up with a lot less than he expected as a percentage of the overall fund because he had to settle with his wife from a diminished pool of capital because the market went down. If you've got a percentage split, it means that it's more equitable in terms of each party having a percentage of risk, if you like, and even return. But that doesn't always suit the particular situation.
So, David, one of the things that I've seen in some of the work I've done recently is around the fact that you might end up with two splitting orders. First, insofar that it may split the wife who's to receive some money, but splitting her balance across to him. So she, in essence, ends up with zero, and then seeing a second splitting order that splits in whatever percentage has ultimately been agreed to. Yes.
We find various reasons for multiple splits in this way. And that can be because there are multiple funds, but it can also be because of an element of financial planning which has crept into this. And if you've got an amicable arrangement, it's, well, possible to achieve certain financial planning goals, which you would not be able to achieve outside of a splitting arrangement like this.
Are there any kinds of sort of planning opportunities with these family law splits in terms of getting the best outcome for both parties?
There are actually, when you're looking at preservation or account equalisation, splitting through the family law arrangement is the best. It's a lousy strategy, though, because of the trigger. And I think, though, the fact that it is so effective, there is a 1-year jail term if you pretend to get divorced. So if you're going into this, be fair dinkum about it.
Yeah.
Look, in terms of how this works, it's probably useful to just pause for a moment on the couple of definitions of member and non-member spouse, because that's an area which a lot of people get tied up on. A member spouse is the person whose account is going to be diminished. A non-member spouse is the person whose account is going to be increased. But because of the description of non-member spouse, it's typical to think that that person isn't a member of the fund. That is not the case. A non-member spouse is only referred to because they're the ones who are going to get the dough. They may both member spouse and non-member spouse be a member of the fund. And in fact, looking at the sort of multiple splits that Aaron mentioned there, you might have a situation where they swap places. One non-member spouse becomes the member spouse and vice versa. Yes, there are opportunities in this respect. And perhaps if I just answer your question there, Miranda, as to what's about, let's just take a couple of simple cases. Firstly, we need to bear in mind that the amount that is transferred from a member spouse to a non-member spouse retains the preservation and tax components of the member spouse. That's an important thing. And taxation components of the member spouse stay with the non-member spouse. Now, that gives us an opportunity to do a couple of things. Let's say, for example, you have a member spouse who's 65, a non-member spouse who's 55. The 65-year-old, by virtue of age, has fully unrestricted non-preserved monies. The non-member spouse, fully preserved. And you've got a situation where the member spouse has $500,000 and the non-member spouse has $300,000. So the older person has the $500,000, the younger person the $300,000. Let's assume, for argument's sake, that they're all taxable component, just because they want to introduce them. We're just talking preservation here. We could do this split in one of two ways. We could say the member spouse merely splits. What we're trying to achieve here is a complete swapping of the balances, right? So the younger person is the 500, the older person is reduced to 300. So we could do that by the older person being the member spouse rolling or splitting 200,000 across to the non-member spouse, the younger spouse. And that would leave the younger spouse, the non-member spouse, with $500,000, which is what was intended. Of that, 200,000 would be unrestricted, non-preserved. But doing it another way, and Aaron alluded to this earlier, the younger spouse could become the member spouse under this particular process and move 100% of their balance, the whole 300,000, to the non-member spouse, which is now the older person. The older person now has an $800,000 balance, all unrestricted, non-preserved. You can see where I'm going here. And the younger person has no balance. The older person now swaps roles and becomes the member spouse and moves 500,000 back to the non-member spouse. So you've achieved the same result. The older person now has only 300,000. The younger spouse, ex-spouse, now has 500,000, but now the younger spouse's 500,000 is fully unrestricted, non-preserved, whereas it wouldn't have been if you've done it on a single process. There are other things that you can do in that respect with tax as well, but I suppose the bottom line with that is that you can't think of this after the event. You can't get the splitting orders and say, well, how are we going to do this in the most effective way? Those particular steps have to be within the orders themselves. Otherwise, you can't do them. And that's why you need to be involved in the particular situation at an early stage.
Yeah. So, David, the interesting thing, I guess, from an administration point of view, this is your area of expertise around admin. We talk about, the need to have valuations. So valuations needing to be up to date, which therefore we may have particular assets that may be listed, may not be listed, and therefore the implications from a valuation point of view, and the fact that as a result of the orders, we may have individuals that may be required to depart the fund as well. So they're just a few things, and I'm sure there are plenty of others. But can you sort of elaborate on some of those and other things that you see as absolutely critical to this process?
Yeah. There's quite a few. Firstly, we're asked to provide member balances. But being an SMSF, even though we process on a daily basis, often we have sometimes very large amounts that we don't know what they are. A person's made a contribution or they bought something, we don't have the evidence. So firstly, the trustees have to cooperate to make sure the accounts are brought up to date. Then, most importantly, I think we have to consider on what basis is this member balance going to be provided. Generally speaking, SMSFs use cash accounting. But here, I believe we have to tick the box in the admin software and do tax-effective accounting, because we need to take into account in the member accounts unrealised gains. No point in doing them without taking that into account. You're going to get a skewed result, and generally the person staying in the fund is the one who's going to end up paying a lot of capital gains tax. So we have to do that. We also have to determine that those big lumpy assets, or ones that are manually valued, and the typical one is real estate, have a current valuation and a valuation that the parties are not going to argue over. Now, they are the trustees. They should have provided us with that valuation, but they're not necessarily both trustees. And in any case, there is a possibility that the member of the fund, particularly if the other one isn't a trustee, might seek to use a valuation which is less than market. So they've got to be happy in that respect. We've also got to find who's staying, who's going. I mean, we might find that they're both staying. We do have funds where the parties have got divorced, they both stayed in the fund together, and they are happy as Larry. I suspect from their relationship now it's much better than ever it was when they were married, and they get along fine. But that's not typical. Typically, someone's going to get out of the fund. In fact, maybe they're already out of the fund.
And the court may actually tell them as part of that once the split has occurred, you're kaput.
True, but that's generally because they've made that decision and it's been a relationship where that's been conducive to a proper result. But and that's generally the case. Now, if you've got a remaining member of the fund whose account is going to be less than the amount that's necessary to hold a big lumpy asset they also want to leave in the fund, you've got an issue. Now, we need to be involved in the situation earlier on so we can be part of the conversation to suggest, hey, maybe instead of running that line down the assets that each party hold, we wiggle it a little bit and say, let's make a bit more of accommodation in the non-super assets and leave more of the super assets in there if we want to keep this particular property, for example, in there. We've also got to determine if there's anyone else who's going to get out of the fund. If it's mum and dad splitting up, there might be kids in the fund. Particularly now we've got 6-member funds, not that many people have taken it up, but still, you might have kids in there and they might be taking sides as well. So what is the fund going to look like at the end of the day? Who's actually going to be there? And then we have to make sure that, is the fund still viable? Maybe the fund needs to be wound up as well. Maybe that's part and parcel of this whole situation when it's done.
You mentioned some of how it's quite an emotional process as well. Do you have any tips for how SMSF professionals can sort of guide clients through the process in terms of managing situations where it isn't very amicable and maybe they're doing things that are making it more difficult than it needs to be?
Absolutely. And I think that SMSF professionals, the accountants, the financial planners, administrators, etc., can provide a very valuable service here by being the honest broker. We stand in the middle. I mean, some of these divorces are really nasty. They might involve family violence. They might involve restraining orders. And sometimes in that situation, you're just not going to get the people talking to each other. They just will not. In fact, in some cases, legally, they can't get in the same room together. Someone needs to do that, a trusted intermediary. And this is where I think that we can come in. Naturally, the lawyers are also in that situation, but the lawyers tend to have an antagonistic relationship, one lawyer to the other too. Not always, but possible. We do have an interesting situation, though, where we have to consider for whom we are acting as well. We're acting for the trustees, we're acting for this member, we're acting for that member. We've got to be very careful on the line that we walk as professionals. But certainly we can facilitate conversations. And we have one now where it's nuclear. And both parties have done all sorts of terrible things. And the nice, neat little package that we have here with court orders and agreements is just out the window. And this is where we can provide a hugely beneficial service, because we can be the people who speak to the tax office. And I can tell you that the tax office have been absolutely marvelous in every situation we have with them. They certainly deserve a huge tick. In situations like this, which can become particularly volatile, particularly nasty, and people can just go off the rails, the tax office, in our dealings with them, have been sensitive, caring, and reasonable. And my suggestion to any situation where professionals are in a nuclear zone, if you can't get the cooperation of one of the trustees to do the right thing, and they may already have done the wrong thing, that's okay. But if you've got at least one that'll do the right thing, talk to the tax office about it, trying to work through a process. That's a huge service that we can do, quite apart from anything to do with compliance.
Very much so. Well, I reckon, Miranda, that's probably as much as we've got time for today. But what I did want to say to you is we throw around the word legend in this industry very flippantly, but David here is absolutely certainly fitting of that title as legend. So I get to work with David quite regularly myself, so I am in the fortunate position. But we have had David on, obviously, on our SMSF Adviser Show for the first time, and David has certainly imparted some fantastic, not only technical insights, but practical insights into this topic, which I know a lot of people would have hopefully got a lot of value from today. So for me, David, thank you for being a part of it. I'm sure we're going to get you on again in the near future. Miranda, anything you wanted to add to that as well?
No, just wanted to thank David for coming on and giving us so many valuable tips in this area. So thanks, David.
Our pleasure. And I haven't said more than I've said.
Excellent. Thanks very much, David. Cheers.
Yeah, bye-bye.
So that was a interesting chat with David there. He certainly offered a lot of valuable guidance and really practical tips on how SMSF professionals might want to approach that whole process with family law splits. What were some of the things that stood out for you, Aaron?
Yeah, I think it just goes to show, even in difficult circumstances, which many of these arrangements would be, there are still opportunities in there that an advisor can really try and bring to the forefront of what is a difficult situation. So David alluded to an example in there about doing the multiple splits, and where in essence you're able to convert what would be a combination of preserved and maybe unrestricted into entirely unrestricted just by knowing how the laws would work and moving the needle into their favour. Now, you might get one spouse that goes, I'm not going to do any sort of favour to my spouse, whatever happened had happened. But there is an opportunity in there. And I think whether it's at the solicitors that are talking to them and the need to maybe go and get some advice around it, or the trustees themselves, I think, just making sure that there is an understanding that there are opportunities that could be utilised in here. And if they don't take advantage of it, well, then, you'll sleep in the bed that you've made. So ultimately, I think from that point of view, there are administrative challenges, but there are also some opportunities to try and get the best outcome for both parties. And if they are accommodating to that, then there's certainly an opportunity to look into that and get the right outcomes that would mutually benefit those two that are parting ways.
Yeah, he definitely showed how there's kind of a lot of good planning opportunities with that. And the other thing that I thought was interesting is how he sort of discussed SMSF professionals sort of being a
honest broker.
I guess, an honest broker, and also some of the resources they can kind of draw on as they guide their clients through that, such as the ATO.
Yeah, so you spoke about that representation. Are you representing the trustees or are you representing a particular party? I think that clarification is going to be critical in the scope of the work that's being done. But like you said, the ATO as regulator can be there to obviously help work through it. It might have multiple years outstanding because the returns have got out of control because of the lack of engagement by one party or another. They've refused to sign documents. You can use the ATO as the regulator to help work through the practical challenges and then work through some of the other maybe more bigger challenges as well. And that may be that the ATO as regulator might just sort of put the foot on the throat a little bit as well if they need to. So that is what the regulator is there for, to make sure that each party has responsibility for their actions inside the fund. Because, as we know, whilst we might have dominant trustees, each party is equally responsible for the ongoing operations of the fund, and the ATO has many levers to deal with that. So, yeah, absolutely. I think that was a very pointed observation as well. So, Miranda, as is always the case, if people have any suggested topics and or speakers, how can they get in contact with us for the SMSF Adviser Show?
So they can get in touch at editor@smsfadvisoronline.com. And thanks again, everyone, for listening in. And we'll see you again soon.
Thanks, everyone. Bye for now.
Interest rates are rising fast, and that means higher mortgage repayments. But some lenders have increased their rates more than others, so that could mean your clients are now paying too much for their loan. We can quickly compare your client's rate with hundreds of similar loans, so you are confident that you've got the best rate on the market, or we'll find you a better rate. Make sure your clients aren't paying the highest interest rates. Call Finny today. Visit finny.com.au and let us take the research and admin out of finding a new rate for your clients.